meeting of the Municipal Code Enforcement Board is called to order. Please stand for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. The decisions made by this quasi-judicial board will be based on the evidence and the facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violations. The respondents will then present his or her case. Both parties will have an opportunity to cross-examine the witnesses. The board members may question any witness. Comments by the board, by both parties, must be relevant to the case. Persons wishing to speak will be given the opportunity to do so by the chairman and must address the board from the podium after giving their name and address. Upon request, copies of material submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and the questions of the city should be directed to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the deputy clerk.
Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Cases will be taken in order tonight. Call for the approval of the minutes of the meeting held on June 14th, 2017. Have all board members received the minutes? Are there any corrections or additions to these minutes? If the minutes, being the minutes are acceptable, I entertain a motion to approve the minutes.
I'll second it.
Motion and second. All in favor?
Aye.
Nays? None. You ready to start? First case?
First case, case number 171027, City versus Gisela F. Smith for property located at 510 Hibiscus Drive. The case is before the board based on alleged violation of Section 12190, uses permitted, and Section 12255, zoning R10, single-family residential. The case will be prosecuted this evening by Code Compliance Director Joe Damian. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Chairman and members of the board. Joe Damian, the Code Compliance Director for the city. This case was initiated by Officer Omar Cortez on April 20th, 2017 in response to a complaint received from a citizen. At that time, he observed and made contact with 3 different individuals who confirmed they were residing on the property and paying rent to the owner. At the time of the original inspection, the owner was not present at the property. Second inspection on May 8th revealed that there were still more than 3 occupants on the property, which was in violation of Section 12-190 of the City Code, and as it relates to Section 12-255, which talks about what type of uses are permitted in a single-family residential zoning district. On or about June 2nd, I followed up after Mr. Cortez's departure from that area and also identified several different people on the property beyond the number that was permitted by the city code. I revisited the property on June 13th and spoke to 2 other individuals that I had not met before. So that was a total of 5. We have police department records that we used as backup to substantiate our case. Then in 3 different instances of more than 7 different individuals that were on the property at the time claimed to be residing on the property. So we also have evidence from the Animal Control Office of the Hillsborough County that they had contact with 5 different individuals on the property that were all unrelated and residing on the property. On June 21st, 2017, a notice of violation was issued based on all the evidence that we had gathered. That violation of section 12-190, as I spoke of earlier, which was the use of the property that was inconsistent with the provisions of the zoning district. The notice of violation was posted in City Hall, it was posted on the property, and sent certified mail and regular mail to the property owner. The property owner was given 10 days to comply with the order. As of today, it is our understanding, and we have received no reports from the property owner that the compliance has been attained. Therefore, I would like to submit at this time evidence in the form of 4 exhibits that actually were provided to me by a agent or the representative of the property owner, which is the property owner's husband, Mr. Larry Smith, who has been working with us in trying to help alleviate this problem and try to come into compliance. So if the board will accept. I
Board will
submit.
accept.
Thank you. Yeah, what I have submitted was 3 eviction notices that have been supplied to us by the respondent's husband, where the 3 of the individuals that are on the property that are remaining have been given notices to vacate. And then there's a 4th item, which is a notice to 2 of the same individuals to basically give them a 7-day notice. As far as we're concerned, until there are less than 3 unrelated people on the property will remain out of compliance. We have come to you this evening to seeking a finding that the violation is existing, and then your determination on whether or not a fine should be imposed at the moment. They have been, like I said, working with us over the past 2 or 3 weeks on the issue, and at this time, I've finished my comments. I don't know if there's any questions you have of me. And I know that the property owner and her husband are both here and available to discuss the matter further.
Is this property have a rental agreement with us? And are they part of the rental program, since I see that they're asking for indebtedness?
Not to my knowledge.
Okay.
But they wouldn't, single-family homes aren't part of the rental permit program. They only apply to. They are.
Yeah, if it's not a resident. I mean, if it's not a relative.
Yeah. SFR is included in the rental program.
There is some provisions in there that talk about if the owner resides on the property there. I'm not exactly sure how that works, but since we don't handle that program.
Okay, is the owner residing, is it
Yes,
homesteaded?
Yes.
Okay.
Yeah, owner is on the property.
You had mentioned, Mr. Damian, that there were up to 7 different renters, so since we have notices for 3, does that mean the other 4 are related, or?
No, to the best of my understanding and based on the investigations that we have been conducting, originally there was up to, I think, 7 different people that had been in and out of the property. Currently, there's only 5 that remain, including the owner. So these 3 in particular that are going through this eviction process would reduce the number of people on the property to 2, which would be compliant with the current code. I think that they can speak on their own behalf as to what their final goal is at the end of this process that they're pursuing. But it would bring the property into compliance if we could bring it down to 2 unrelated individuals on the property.
In addition to the owner.
No, including the owner.
Right, so just
So there will be just 2
two
people,
unrelated.
right, the owner
additional
and one other
unrelated.
person. Which is, I think, where it'll, if those 3 people are evicted, that's where we're gonna be.
So just to clarify, it's the owner and one other person of their choice
Would remain if,
would remain.
you're right, if those 3 people are removed.
Is it 2? I thought it was the owner and two
No,
other individuals
No,
unrelated.
no, 2 in total,
Okay.
including the owner.
Okay. I
That's
think
my
there's a
understanding.
little bit of confusion here. I think it's a total of 3 people can be residing, unrelated people can be residing in the same residence.
Correct.
And I think what Joe Damian was saying was that if they evict the 3 people that are on the eviction notices, then they would be in compliance because the city believes at this point that there are 5 people in there, although I have reason to believe that there are currently 4 additional people other than, based upon a conversation I just had with Mr. Smith. So I think they're working their way, one of the 5 has already left and they're working their way through the other folks.
All right. Thank you.
You're welcome.
Do you have
Actually, it's actually for the city attorney. Did you look at the eviction papers he handed us? I don't know if you saw them or not.
I did look at them.
From the city, are they legit? Like, I don't know enough about them, that's why I'm asking you.
So I think the purpose of the eviction, what I can comment about from the city's perspective is, obviously, they're signed by the owner, so they establish, and it's essentially an admission that those 3 individuals are in fact living in the house right now, and they're unrelated. The legal sufficiency of them, I can't really comment on, other than to say that I know that he has, and by he, I mean Larry Smith, the husband, has pulled forms from the Hillsborough County Clerk's website and is working with, he has not hired an attorney, but is, I believe, doing his best to follow the proper procedures.
And if I may clarify, the reason I submitted that is to confirm the validity of the violation that we wrote, that I think it's confirmed by the owner. We still will not be in compliance until we can confirm that the people are gone.
Thank you, Mr. Damian.
You're welcome.
Are you willing to speak? Come on up. Give us your name and address, please.
I'm Gisela Smith.
Giselle? Are you going to speak together, or are you going to speak
No.
one
I'll
at a
speak.
time?
First of all,
Your
let me
name,
say,
please?
pardon me, sir?
Your name, please,
My
and
name is Larry
address.
Smith. Address, 210 Holland Avenue.
Thank you.
I do not live and never have lived at the address in question.
Okay.
We've been separated for years and years.
Okay.
The goal of the commission, as I'm understanding it, and in the rules and regulations that I understand, is you're allowed to have 3 unrelated people in the house. Actually, what I'm trying to get it down to is 1 person in the house, that being her, the owner. And she is looking at, actually thinking about maybe even moving out of the home. So, but that's maybe in October or November. So my goal is to have 0 people that are unrelated in the home. That's my goal. If I can explain a little bit about the eviction notices. I've got 2 people who have been telling me, because I've been asking them for several months, please, y'all need to move out. First of all, it was, well, I can't move because I'm having trouble finding a spot. I'm a sexual predator or something like that. So I said, well, you need to get out, you know what I mean? Verbally, trying to tell them all, trying to be nice, because Lord knows the police have been over there enough as it is. So anyway, when we go into that, but anyway. I've got two of them that are actually, one of them is not on the list, Edwin Smith. He's going to be leaving in August, and he's pretty well, is going along with what he told me. And I agreed to August because I knew we would come up under your bar or your standard, what it is. The lady, Dana, I presented her with a 3-day notice, and unfortunately, the neighbors called the police rather than watch the show. And so that was not a positive experience. So then I knew I was going to have to, go ahead. And then the other guys told me, well, we need, first of all, they couldn't find a spot. Then I said, you need to be out by July. They said, well, in June. They said, well, we don't have the money. Well, we'll get our checks in July, so we'll be ready to go in July. Then when it came July, I said, okay, folks, you guys leaving? Well, you're going to have to evict us. We have our rights. After a moment of composure there for myself, because I'm pretty much a person, if you tell me something, I'm expecting you to do that. That's just the way it is. So I said, okay, if I have to evict you, that's what I'm doing. The 3-day notice actually asks for rent, because my understanding is that's the quickest way to get, and I'm not a lawyer, but I did go down to the courthouse and got their pamphlet, and I have all their papers and their forms, and I'm trying to use this as a go-by. So if someone had a question, is it the correct format? Yeah, I'm using this as a go-by, and I believe it to be. Okay, so anyway. But anyway, so I gave them a 3-day notice. The 3 of them had the 3-day notice because that was supposed to be the quickest. And then I also gave them a 7-day notice. I mentioned the 2 people in there that by name. But I also, in the letter, if you look up in the letterhead, said, "and all other residents," or something like to that effect. Because 2 of them that were trying to get out said, please don't mention our names because it would show as an eviction through the courthouse, and we would have trouble getting another place to stay. Lord knows I don't want to stand in anybody's way of getting another place to stay. You know what I mean? Because my goal is to have 0. So I said, okay, but I'm including them since they are residents in the 7-day notice. 7-day notice just basically says, hey, folks, effective, because I have to give them 7 days notice, effective the 15th, they're on a week-to-week tenancy, and effective on the 15th, that's 7 days from when I gave them the notice, we're out of business. You know what I mean? We are no longer renting, whatever you want to do. Anything beyond this time, you guys are sitting here illegally or without compliance, or whatever you want, or whatever the correct proper term would be. In other words, get out. I'd like to have no one in there. And certainly I don't want anybody in there that thinks, to me, a PO is a purchase order. To them, it's a parole officer. So there's a big difference in how we think. But that's basically why the 2 forms submitted at the same time, because I'm trying to expedite the process. Questions? I've talked enough. I
Any
guess.
questions?
Yes, sir.
So how many people are actually living there?
There are 5,
There are
including
5.
the owner.
And are you collecting rent?
No, I'm not collecting rent. I'm trying to get them out of there. I haven't collected rent in over a month.
And do they have leases?
No, there's no written lease.
Okay.
This was created by another person who's currently incarcerated. He brought all these people in. I'm just I don't care about the rent. If you want the truth, just want them out. And also on the doggy side, I know this dog's been here before. We've so far managed to get rid of 7. So we still have 3 dogs. However, we also have 3 residents, and I'm looking at the dogs being a symptom rather than a problem. We get rid of the people, we get rid of the dogs. That's the way I'm looking at it. So hopefully we won't have one person living there and no dogs.
And one other
And peace
question.
and quiet. Yes, sir.
So you do not live there?
No, sir, never have lived there.
And does Mrs. Smith live there?
She lives there,
You
yes, sir.
currently live there now? Okay.
Yes.
That's it.
Any other
Oh,
questions?
most important part. We are not in compliance, needless to say. We would like to have an extension so I can have the eviction process go through. Sorry, forgot that part.
Okay. Well, let me ask one question.
Sure.
Do you have any of these people that you've noticed given signs that they're going to comply?
Yeah.
All of them are giving signs, but 2 of them are only giving signs that they're going to have to evict them before I can. The other 2 are actually out actively looking. One of them is actively looking for the job. The one is supposed to leave on August the 1st. The Dana, she's trying every day to go. and I think she'll be leaving in within the next week or so. The two other gentlemen, they're gonna go, and they agree to go, but I'm gonna have to evict them. It's a waste of money and a waste of time, but some folks are just that way, I guess.
Okay, thank you. You have a question?
Yeah. You said you haven't collected rent in a month. Have you collected rent previously from these tenants?
Did y'all collect money from them?
Are they in? Okay. And
She
are
did,
they-
evidently.
She did?
She did a long time ago, so
Okay.
she just,
And are they receiving mail at this property?
yes, some of them do.
Okay.
I don't live there, sir, so,
No,
but
no,
I
I'm
know,
just-
I know a couple of them do receive mail there. Now, whether all of them are receiving mail there, the truth is, I don't know the answer to that question.
I'm just, if you look in your process for evicting, there's going to be some things about that. That's why I want to know.
Oh, okay.
How long it's going to take you to get through when you partner with with the county to get them out, if you have to go that route.
I'm gonna have to go that route almost assuredly. And I'll be truthful with you, I've never done this process before. I'm kind of like learning and reading my
don't-
little book. In fact, the gentleman here was kind enough to answer a couple questions that I had. I appreciate that very much.
It's a tough process, but I wish you the best on that.
Thank you. If there's any shortcuts, I would be glad to hear them, sir. Other than just going in there with a shotgun and then the police would show up, and that wouldn't be a good idea.
Wouldn't be good for you.
No, it wouldn't be good.
Okay, thank you.
Yeah, thank you very much.
Is there anyone else wishing to speak on this case? There being none, ask for a motion.
I'll make a motion.
Thank you.
Based on the testimony of Code Compliance Director Joe Damian and Mr. Larry Smith and Giselle Smith, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Gisella F. Smith in case number 17-1027 to be guilty of violating sections 12-190 and 12-255 of the city code, and give the respondents until August 9th to come in compliance with code sections in question. If the property is not brought into compliance by that date, a fine of $75 per day shall begin to accrue on the following day.
Is there a second?
Oh, should accrue to until the violator provides the city with evidence that the property has been brought into compliance. All right, I didn't finish the last sentence there.
All right. Is there any board discussion? No discussion? All in favor?
Aye.
Opposed? No. One opposed? Next case.
Case number 171199, City versus Scott W. Waters for property located at 9301 Rolling Ridge Place. The case is before the board based on alleged violation of Section 12860, inoperative vehicle, outdoor parts storage, and Section 1034 sanitation, keep premises clean. The case will be prosecuted this evening by Officer Tom Baroni. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Tom Baroni, Code Compliance. This case this evening originated from a neighbor's complaint that I received on May 31st, 2017. My inspection on the morning of June 1st noted a Ford pickup truck in the driveway on floor jacks, overgrown conditions throughout the yard, and a large pile of concrete on the north side of the side yard. At that time, I left 3 door hangers with a reinspection date of June 7th, 2017. My reinspection on the 8th of June noted no change, and therefore a notice of violation was prepared later that day with a compliance date of June 18, 2017. Since I was unable to make contact with the tenant, I posted the notice at the front door and requested copies be sent certified and first-class mail. I also requested that a notice be posted at City Hall for the 10-day requirement. On the 21st of June, my inspection noted that the yard had been mowed, but the concrete and the in-op vehicle in the driveway remained out of compliance. At this time, I would like to submit photographic evidence of the violations. Exhibit number 1 shows an inoperative vehicle on floor jacks, which was taken on June 21st. And the other photo is exhibit number 2, it was taken on June 21st, and it shows a pile of concrete stored in the side yard. At this time, I'd like to submit.
Board will accept.
The vehicle was removed off the jacks on July 3rd, and which I'm going to submit an affidavit of compliance, but the concrete still remains stored on the side of the yard, and therefore it remains out of compliance. So I'd like to submit an affidavit of compliance for the.
Board will accept. I have a question for you.
Yes.
On the concrete, is he doing some renovation or construction? or-
There was a shed that was behind that concrete. The shed was demolished, so I'm thinking that that concrete came from that shed. So that's where I think that, but
Okay.
the shed material has been removed off the property, but the concrete has not. So,
Okay. Any other questions?
Tom, I know there's been various issues with this one, but I guess there wasn't ever any, whatever debris or however it was stated in the past. I mean, I know there's other violations with it, or
Yes.
have been other violations. That
Yes,
keeps it from, I guess my question is, it's not a repeat violation
That's correct.
because there wasn't debris or whatever the
Right,
concern was in the
right.
past. There were other issues.
yeah, I have a running pool fine. I have a fence that's a running fine. And the pool cage, I believe there was a fine for that one as well. So the grass at the time when I first visited was probably about 2 feet high. So grass grows and they mow it and it's in compliance. So it's a very tough case to present because, Sean?
No, I'm good.
Oh, I thought you had a question. Okay.
He's asking the question.
Okay, I'm sorry, I'm sorry.
Mr.
What,
Stats?
what, wasn't the pool cage removed?
Yes. He had sold the metal for money.
And do we know if the shed was metal?
No, it was wood.
Oh,
It
okay.
was wood. I don't think so. No.
I had a feeling that might have been where it went.
Any other questions? Thank,
Yeah.
yes.
I do have one now. We talked to the owner? Because I know that he was out of the country or something on the other violations?
Well,
or-
apparently, the rumor was that he was in Afghanistan. He was a contractor. But he has changed his mailing address to Palm Harbor. So there is a mailing address now for Palm Harbor. So I have a return certified letter from, I guess, his wife, or girl, it says Doris Waters. So I'm guessing it's his wife or his mother. I'm not really sure. But I've never made contact with this individual in 10 years. So, but he's now gonna be getting these letters, that he's gonna know there's a running fine at his property. So,
Thank you.
but I do get a lot of complaints about this property, so.
One more?
I guess I have one more question. Since you do finally have an address, then does he get noticed on all the things that we weren't able to get into his hands in the past for the pool thing and the fence
Oh,
thing
yeah,
and all that?
the
So
city sends out, I believe every 3 months, Kristen, about a lien, like a liens, the running fine. The city doesn't send out anything? No. So then,
I was just kind of curious as
No.
to whether he'd been notified of all these other issues and concerns.
I don't know.
No, but we probably could.
Okay. This is Roland Ridge.
Well, I can speak to one item, if I may. The tenant,
The tenant, the guy who's living on the property, has communications with the owner. Now whether, and he's well aware of the problems that are out there, and he knows what's going on, so, I know we recently had a new address, that we resent it. They actually signed for the green card. We thought they may show, but if he's in the country, he should be aware of what's happening.
No, for Joe.
Oh, for Joe.
Did we put up that orange fencing? Did the city put that up?
Originally, we did, then it came down, then somebody else put it up, and we're already initiated, we're gonna put a fence up there. Okay, it'll
I just
require-
noticed in the picture it was down, and I didn't
Yeah.
want us to be liable by having that
No,
be
no,
ours that we put up, and it's now
I mean,
not doing
well,
its job.
I don't think it's our liability. I think that's a property owner's liability, but we're moving ahead with there's another notice of violation that'll go. I don't even think I've talked to Mr. Garding about this, but our goal is to take some sort of action, because the pool with the rainy season starts to fill, and they apparently aren't doing anything about it. They took the time to demolish a little shed that was in the back and get rid of that, but, and it's, it's 35 feet of fence at most.
On the complaints we've had and ongoing, I mean, that's
Yep.
at this point. Thank you.
Thank you. Do I have a motion for,
Based on the testimony of Code Compliance Officer Tom Barone and Code Compliance Director Joe Damian, presented to the board at this hearing, the documentary evidence found by the board, I make a motion that the board find Scott W. Waters in case number 17-1199 to be guilty of violating section 10-34 of the city code, and give the respondent until August the 9th to come into compliance with the code sections and questions. If the property is not brought into compliance by that date, a fine of $150 per day shall begin to accrue on the day following compliance date and continue to accrue until the date the violator provides the city with evidence that the property has been brought into compliance.
do I have a second?
I second.
Thank you. Any board discussion?
We're gonna have we're gonna address the compliance on the inoperative vehicle. And we have to.
Not now.
Okay, all right, we're doing another motion. All right.
Any discussion? All in favor? Aye.
Aye.
Opposed? All in favor. Do you want to run that's,
Well, we were talking, I just told him, since it came in compliance, we didn't have to do anything with that. The part that's in compliance, we didn't have to mention it in our motion.
We
We still have to
find-
have a finding that they were out of violation, that there was a
Right.
Another
violation.
motion, then, okay.
Yeah.
yeah.
Based on the testimony of Code Compliance Officer Tom Barone and Code Compliance Director Joe Damian, presented to the board at this hearing, the documentary evidence received by the board, I make a motion that the board find Scott W. Waters in case number 17-1199 to be guilty of violating section 12-860 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
I'll second.
Motion been made and seconded. Or any board discussion? All in favor? Aye.
Aye.
Opposed? No opposed. Next case, please.
Case number 17-1215, City versus Lillian Fong Ho for property located at 12842 North 56th Street. The case is before the board based on alleged violation of section 12984AI, signs permitted window 25%. The case will be prosecuted this evening by Officer Barone. The city has evidence that the notice of violation and notice of hearing were properly served.
Tom Barone, Code Compliance. This case this evening originated proactively on June 2nd, 2017. My inspection that morning noted that the supermarket front windows did exceed the 25% sign coverage. I visited the store employee and advised her of the city codes on the window signs and gave her 2 weeks for a reinspection date. My inspection on the 16th of June noted no change. Therefore, a notice of violation was prepared for both the owner of the property as well as the owner of the business. I requested copies be sent certified in first-class mail to the owner and posted at City Hall for the 10-day requirement. I hand-delivered the notice of violation to the business employee. On June 19, 2017, I received a phone call from the owner's lawyer requesting an extension on the compliance date of June 26, which I denied. I requested that they show up tonight at the hearing, but if they requested additional time if needed. My inspection on the 28th of June noted no change. At this time, I would like to submit photographic evidence of the violations that were taken by me on June 2nd, which was my initial visit, and June 28th, showing 90% window coverage on the storefront.
Will accept. Have they had shown any interest in complying?
Yes, the property is in compliance. I didn't finish my, it's okay, it's okay. The supermarket owner came in yesterday, and he showed me pictures of what he removed from the windows. I visited the property today, and he's in compliance. Looks totally much better than what for my likings, and so,
You know how I feel about it.
yes, yes. And actually, this is up by, in the north zone, so this is, therefore, it's in compliance. So I'd like to submit an affidavit of compliance for the owner of the business and the owner of the property.
Thank you. Board will accept.
Okay. And I'm just looking for a finding.
Thank you. Any questions?
No, I just want to make a motion.
Thank you.
Okay. Can I get a motion?
Sure. Based on the testimony of Code Compliance Officer Tom Barone, presented to the board at this hearing, the documentary evidence received by the board, I make a motion that the board find M&B Supermarkets, Inc., Ahmed Mohammed, registered agent, in case number 17-1215, to be guilty of violating sections 12-298AI, subsection, of the city code, because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
A second?
Second.
Any board discussion? We have a motion and a second, and ask for all in favor?
Aye.
Opposed? Passed. Next case.
Case number 171243, City versus Betty J. Owens for property located at 505 Brentwood Drive. The case is before the board based on an alleged violation of Section 12861B7, fences appearance. The case will be prosecuted this evening by Officer Sal Scrozo. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Sal Scrozo, Code Compliance. This case was initiated by a citizen complaint on June 9, 2017, of a dilapidated fence on a neighboring property. My inspection on that day revealed a section of the fence had fallen into the neighbor's yard. Further inspection also revealed that the entire fence was no longer structurally sound. The home was unoccupied, and therefore I issued a notice of violation the same day and gave the respondent until June 26 to bring the property into compliance. I posted the notice at the home and mailed copies, both certified and regular mail, to the property owner's address. And I also requested that the notice be posted at City Hall for the required length of time. My inspection on June 27th revealed no change. At this time, I'd like to submit photographic evidence of the violation taken by me on June 27th, 2017. Exhibits 1 and 2 depict the fence damage on the east side of the property. Exhibits 3 and 4 depict fence damage on the north side of the property.
Board will accept.
Today's inspection revealed no change, and therefore the property remains out of compliance. This is a case where an elderly couple was living there, and they had a reverse mortgage. Unfortunately, the husband passed away, so the wife went to live with the daughter. We've been in constant communication with the daughter, and she's been very helpful in getting some information. But they had a reverse mortgage. They put the property up for sale. Unfortunately, they weren't able to get a reasonable offer, so they turned the keys over to the mortgage company. I did contact the mortgage she gave me the information. I did contact the mortgage company. They took down the violations, and they're supposed to have the preservation company call me back, and we can discuss, how to remedy the situations. There's a pool in the backyard, which I can't get to. It's so thick, and there's another, I guess, water feature. It's more like a pond in the backyard, so you really can't get back in there. But the entire fence really has to go. But we explained that to the mortgage company. I think they'll, do the right thing. They've been taking care of the property since. They've been mowing the grass and things like that. But as soon as I hear from them, we'll know how long this is going to take. Unfortunately, the process, because they handed it in early, and I'm not an expert on reverse mortgages, but because they handed in the keys a little early, I think they almost have to go through the foreclosure process. But it's going to take, they said, until probably April of next year until they take legal ownership. So we're hoping that they do the right thing and fix the fence, take care of the pool and that pond in the backyard.
So in your conversation with them, they are aware that the pool, like for putting dunks in it or?
I've been putting dunks in there. As a
Oh,
matter
you
of fact,
have?
today,
Okay.
I put another dunk in there. I also, the person that had filed a complaint lives directly next door. I also gave them a year's supply of dunks.
Okay.
And we also contacted the Hillsborough Mosquito Control, and they have come out and already tested it, and they said there's a large number of mosquitoes, and they're gonna spray. So we're doing what we can, to remedy the situation, but as of right now, it's a mess.
Question?
Yes, sir.
I have to assume then, Sal, that since, is the pool screened, or?
As far as I can tell, because again, I can't get back there to see it, unfortunately, that's why it's not there. I haven't been able to see it, and I haven't been able to get access to that pool. It looks intact from what I can see. And I guess it's somewhat secured because it's almost, there's water all around that opening where you can't even get back in there. I tried, and you can't. The water is about 2 feet high, and there's so much foliage in there that you're unable to get back in there. But that's the reason why you don't see the pool on there. But I did explain that to the bank, so they have the pool, they have the water feature, and they have the fence to deal with, and they know that.
Okay. Any other questions? Thank you.
Thank you.
Being there is no one else to speak to this, can I get a motion?
I don't have a motion, but I got a comment on this one. I guess
We
since,
want to get a motion, then we'll comment.
sure.
I'll make a motion.
Thank you.
Based on the testimony of Code Compliance Officer Sal Scroza presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Betty J. Owens in case number 17-1243 to be guilty of violating section 12-861 subsection B subsection 7 of the city code. Give the respondents till August 9th to come into compliance with the city code sections in question. If the property is not brought into compliance by that date, a fine of $100 per day shall begin to accrue on the day following, August 10th, and continue to accrue until the date that the violator provides the city with evidence that the property's been brought into compliance.
Do I have a second?
I'll second.
Thank you. Any discussion?
I guess my discussion here is that, you know, obviously it's in the point of going back to the bank, so we have to do something, so we made the motion and we're gonna pass it, but it's kind of really, I don't even know if it's a moot point. I mean, it's kind of a semi-waste of time, really, but.
This is what I was gonna question. Why are we doing this against this lady? She's not even there. And
It's
she's turning
still-
the keys in.
I mean, something has to happen, I realize that, but it just seems like kind of a, you know.
It's still a case before us, so we have to do
Right, we have to
finding out.
rule on it, I understand, I mean, like I said, I
And it-
understand it, it's just
And what we do will go with
a
the
bit
property.
frustrating.
So,
Well, I'm with you. I mean, it's frustrating that it's at that point, but until that, his filing is made at the courthouse, and it is in their hands, the mortgage company's hands, it's still in her hands.
Right.
To handle that, and I'm sure the city would have pulled it back if they thought it was gonna go over or had been over. Hats off to Sal for talking to the mortgage company and for what work they have done. I'm concerned with the pool and the lake and all the foliage, but that's not before us tonight.
all right. Any other discussion? Okay, all in favor?
Aye.
Opposed? No nay. Thank you.
Okay. Unfinished business. Case number 170403, City versus J.H. and Betty Morris for property located at 12902 North 53rd Street. An affidavit of noncompliance was submitted by Director Damian, dated June 15th, 2017. Case number 170570, City versus Milford v. Collins for property located at 10046 North 52nd Street. An affidavit of noncompliance was submitted by Officer Baroni, dated June 15th, 2017. Case number 170723, City versus Benjamin and Amanda Payne, Don P. and Peggy Graham for property located at 8208 Volusia Place. An affidavit of noncompliance was submitted by Officer Scrozo, dated June 15th. Case number 170773, City versus Ivan Baby and Sally Joseph for property located at 7523 Terrace River Drive. The expiration of compliance is tonight at midnight. Case number 170777, City versus Yusef Ad-Jabari for property located at 104 Mission Hills Avenue. An affidavit of compliance was submitted by Officer Baroni, dated July 12th. Case number 170813, City versus Robert M. and Deborah A. Schaller for property located at 339 Glen Oaks Avenue. The expiration of compliance is tonight at midnight. Case number 170846, City versus Wells Fargo Bank National Association Trustee C.O. Shapiro, Fishman, and Gash for property located at 10310 Council's Way. The expiration of compliance is tonight at midnight. Case number 170869, City versus NCRC Housing Rehab Fund for property located at 5205 East 131st Avenue. The expiration of compliance is tonight at midnight. And then I have one more. An affidavit of compliance was submitted for case number 142881, City versus Estate of Joanne B. Carroll for property located at 5202 Blaine Drive. This is going to be an amnesty case that's going to come up next. And then I can go ahead and continue with the liens list, and then we
Sure.
can do amnesty, if that works.
Yes.
Okay, great. I have affidavits of compliance tonight on the liens list for case number 141147, City versus Thomas J. Urbachek, 1113 North River Hills Drive. Case number 151435, City versus Thomas J. Urbachek, 1113 North River Hills Drive. And one last compliance for case number 160241, City versus Yusef Ad-Jabari, 104 Mission Hills Avenue. And then I have non-compliance, affidavits of continuing non-compliance for case number 05557B, City versus Jeffrey L. Rhodes and Vernica L. Rhodes, 708 Grand Circle. Case number 080292, City versus Christopher York, 7604 Leon Avenue. Case number 121424, City versus Stella M. Hunley Harrison, 9603 Overlook Drive. Case number 142840, City versus Iman Osman and Asma Alzine, 12415 North 59th Street. Case number 145858, City versus Melissa A. Gazzola, trustee, 13203 Sanctuary Drive, Cove Drive, Unit 304. Case number 151689, City versus Iman Osman and Asma Alzine, 12415 North 59th Street. Case number 152210, repeat, City versus Michael S. Rice and Diane M. Rice, 511 Rolling View Drive. Case number 152510, City versus Coy Lee Berry, 10014 North 52nd Street. Case number 152858, City versus Craig Brunstein, 418 Ferncliff Avenue. Case number 160257, City versus Natalie Anderson, 105 Deer Park Avenue. Case number 160300, City versus Stella M. Hunley Harrison, 9603 Overlook Drive. Case number 160491, City versus Richard D. Warren and Deborah L. Warren, 108 Mission Hills Avenue. Case number 160561, City versus Estate of James Edward Hinkle Jr., 7504 Gadsden Drive. Case number 161433, City versus Scott Waters, 9301 Rolling Ridge Place. Case number 161752, repeat, City versus Craig Brunstein, 418 Ferncliff Avenue. Case number 2328, City versus Scott Waters, 9301 Rolling Ridge Place. Case number 2375, City versus Estate of Charlene Amato, 113 Glen Ridge Avenue. Case number 162397, City versus Dudley Black, 9408 Hidden Ridge Place. Case number 162514, City versus Scott Waters, 9301 Rolling Ridge. Case number 162515, City versus NCRC Housing Rehab Fund, Marquita Davis, 5205 East 131st Avenue. Case number 170092, City versus Asset Trust Holdings LLC, trustee, 6620 Jennifer Drive. Case number 170469, City versus Nathan A. Meyer, 107 Greenfield Avenue. That's all for liens list.
Would you like to take a break?
Yeah. I would. Thank you.
Thank you. You ready for the liens list review?
Oh, amnesty?
Amnesty?
Okay.
Would you like to do that?
Were there any questions on the liens list? Are we good?
I think we're good. The other board action we have tonight is the consideration of the amnesty program applications.
So case number 082378, City versus Juanel Oliver for property located at 207 Amber Lane. The amount of lien is $500 and the applicant is Juanel Oliver. And the other case is for case numbers 132384 and 142881, City versus Joanne B. Carroll for property located at 5202 Blaine Drive. The amount of lien is $48,350 and the applicant is HM Investing LLC.
Good evening once again. On case number 8, 2378, the property at 207 Amber Lane, the amnesty program application was properly received on June 28th. The applicant met all of the criteria of the program. They were notified on July 5th that the application had been received and had been reviewed. The original lien amount was $500. We did the calculations based on the program criteria, both by reduction of 85% or by 15% of the market value of the property. In both instances, that exceeded the maximum amount, or actually, I apologize. Based on the reduction of the lien by 85%, the outcome was $75. And also, based on the program criteria, that's the amount that the lien would be reduced to. So it goes from 500 to 75, and the administration's recommending that the board approve this application, as it met all program requirements.
Thank you. Motion from the board, or any questions first, or? Of Joe? Okay. We'll take a motion.
Yeah, I got a question, sorry.
Question
know
for
I've-
Joe? Question for Joe?
Yeah, I know I'd missed the meetings and I wasn't part of this program. However, I am a proponent for some certain properties. This was going back to '08. My concern with this is if do we know, maybe it's a moot point, what the violation was, what the city costs are? I noticed I didn't see that on this form here. And, I'm looking at a reduction down to $75.
From 500.
Huh?
From 500? Yeah.
Yeah, I mean, to record it, I mean, the city probably costs the city more than that to record it, and it's been on the books since '08. I mean, are we gonna be privy to that kind of information, or is it just gonna be this?
Well, if I can answer, and I'll let Mr. Garding weigh in. This was a program that was approved by the city council with very specific criteria.
Okay,
And as long as the applicants met that criteria, there was formulas that were laid out in the resolution that we have to follow. And based on those formulas, that's what it comes out. It doesn't really look at what the original violation was or how long it took, or it doesn't, it was a program that was designed to encourage people to bring the properties into compliance and give them a break on the liens that had been recorded.
so I'll ask the question, are we not going to receive, based on this program and the way it's outlined and what I see here, is we as a board will not get any information as to what it cost the city to handle this case?
I mean,
Is it yes, is it a simple yes or no?
the information is available. I just don't know how it would impact the board. The board cannot alter these numbers.
Well, I mean, the board can also not make a recommendation to accept this lien reduction. I mean, if I'm living next to a property that's been
Right.
like that for 48, for years, and, it's taken a long time to get there, or, I know the city's spent tons of money on this case, and I'm a taxpayer.
Right.
I would want to know, because when it comes time to talk to those people that make those decisions, and I cast my ballot in November, that might have a prevalence to it. So I just want to know, I'm just asking for this because I wasn't here.
Yeah.
It's kind of yes or no. Are we going to have, is this it? We're not going to get the cost of what it's cost the city to process this?
Joe, I can answer that. So I think, what Joe was saying is that the information, we can certainly find that information for you if you'd like, but the way the ordinance was set up was that essentially your role as the board is ministerial, in that the amnesty program, the way it's designed is to give people a one-time kind of option to bring their, the property into compliance. And if they meet all the other criteria, which are outlined in page 2, then they qualify for the reduction. It's not the lien reduction process. So it's not that the board is making a recommendation. The board is simply determining, have all the criteria been met on page 2.
So we don't have any say as to the price or not?
We can deny
Right,
it.
it's
can deny it.
We can deny it.
Yeah. We can vote against it. Is that right?
You can vote against it, I mean, sure, but you would have to be, that one of the criteria have not been met, right? So it's not that, Joe, just out of curiosity, I mean, I think, wasn't this like a rental permit or something? This was a $500 cap case.
That's part of the problem. We don't even know what the violation was previous, and is anybody checking them to see if they're compliant?
Well, they're not qualified for the amnesty program until they bring their property into compliance.
Yeah, I
Or
mean,
are
this-
we actually checking that? That's what I'm asking.
Absolutely, no, if not, I mean, we confirm everything that's on here. All the yeses that you see on there are things that we have checked and confirmed that are accurate, or else there would be a no in that column.
I mean, I'm just saying the person lives in Ohio. You know, when I think of that,
Yes.
I'm thinking of someone that's moved into the city, bought a house, and has rehabilitated a house, not someone that has it as an investment property. But I don't know the case, because I don't know what the violation
Right.
was on that.
But the amnesty program doesn't make that distinction.
I know, and that was those are my two questions.
Right.
Do we get that information, and do we get the city costs? And the answer is no.
Right. Yeah.
Just so the citizens know.
But we can certainly find, I mean, you know, we can find that information for you.
No, and then the only other thing that you
I mean, the
mentioned.
costs wouldn't be calculated. The costs are something that, you know, for purposes of the lien reduction are separately calculated. It takes some time to do that. The costs were not separately calculated, but we could easily find out, I mean, Kristen could probably pull up right now the two code enforcement cases. We could tell you.
No,
the
I,
violations.
I'm not asking for that done, I'm just trying to understand this amnesty program, and
Okay,
then
yeah.
you opened the door just now on something that I perplexed on. If all the correct, so therefore, and correct me if I'm wrong, if all the criteria is met on this sheet, we can't deny it?
Well, you can vote.
Is that what
You
you,
can vote- you can
did
vote
I hear
against
you
it.
correctly?
You still can vote against it.
I didn't think we could. I thought it was set up, if they met all the criteria, this is it. This is the whole lot, it's a one-time program. and we
You're,
can regulate it.
yeah, so the amnesty, yeah, the way that it's designed is that the amnesty, in your role in the amnesty program is just to make sure that the criteria are met for the application. And that's essentially it. Because the city council has already decided that they're going to do this one time, the city has, they're gonna do this one-time amnesty program. The code enforcement staff make sure that they have complied with all of it. Your job is to make sure that they do too, you know, or just to make sure that they've met all their requirements. If all the requirements are met, then you vote for that the application has, you know, been properly completed.
Yeah, I wasn't here for the program.
Right.
I just, I don't know why it comes before us if we don't have any.
It expires soon though, doesn't
But,
it?
yeah, that was my
It's this-
point.
Yeah.
It's already expired. hasn't it?
You may just get a couple more.
Is this the last month?
We have, I think, if I'm not correct, one application that
Left?
came in prior to the end of the period, which would be heard at the August meeting.
Mr. Lloyd may just say, I think you'll see that on the other amnesty application, the value of the program.
And
but it-
I hope that we do get something to, I'm a proponent for doing that for the right cases on the case-by-case basis, and I'd hope that we'd have some kind of say in the matter when it comes to us. So if we do decide to do this again, hopefully we can have some better constructs, that's all I'm asking.
Hopefully, no, it's supposed to be a one-time program, period.
Okay. Thank
it's
you for
also-
your time, thanks for indulging.
Right, and so the idea too behind the program is, I mean, not that I'm advocating for the program or anything like that, but just to explain it since you were here, is, you know, there are lots of properties that sit with that, and people aren't fixing the ongoing fines that have been existing for years and years and years, and that are blighting certain parts of the neighborhood. So the idea is, hey, if we incentivize you to come into compliance, we're gonna offer this one-time amnesty issue, because otherwise, I mean, what people don't have, if they have a $100,000 running fine, there's no incentive for them to fix it. There's no way they could ever afford that.
No, I agree with you. I mean, just like the case we heard on the one where they had the reverse mortgage. If I was the sibling or the child of that, I would probably go fix it so that I wouldn't be there. Or if the fine had accrued a lot, give me a chance to go fix it and let me pay a reduced amount so I can sell it. So I don't have a lien on it. So, you know, I mean, I hear you.
Right, and then,
But
you know,
my concern is I just didn't know the constructs and was lacking some information that would possibly help me make a decision.
Sure.
But as I understand now, I don't really have a decision.
well, I think, you know, I think if you look at it this way, it's not the same as the lien reduction process. Right? This is something completely different. This is, you know, an amnesty program to incentivize homeowners and property owners to bring their property into compliance immediately. And, you know, several people have taken advantage of it, and lots of properties have come into compliance. I mean,
Well, thank you again for indulging me and welcome back. Sorry to drag it out.
Well, you would be happy to know that the car property came into compliance through this
Awesome.
process. So.
Awesome.
Okay,
Shirley Carr, great.
any more questions?
No, that's it.
Could I get a motion? Anyone?
I can see that Sean is just toiling in his mind.
No, go, if you,
I make a motion that the Code Enforcement Amnesty Program application for 5202 Blaine Drive, Tampa be accepted.
Any more discussion? A vote, all in favor? Aye. Opposed?
nay.
One nay.
Wait, okay. Question here. You said 5202 Blaine Drive. That's the second one? And then you said nay, so I don't think you want it to nay that one. So maybe just
Do it,
fix
redo
that
it.
real
I'm
quick.
sorry.
Amber Lane.
I apologize. I make a motion that Code Enforcement Amnesty Program application for 207 Amber Lane be accepted.
Second? I'll second. Approved and seconded, or made and seconded. Any discussion? All in favor? Aye.
Aye.
Opposed?
I'll stay consistent, nay.
All right.
All right.
Thank you.
The next case is on property 5202 Blaine Drive. It's case numbers 13-2384 and 14-2881. Application was received on June 28th, which was consistent with the program requirements. All other criteria of the program were met by the applicant. They were contacted and advised that the application had been received and reviewed. That original lien amount was $48,350. We calculated it at 85% of the lien, and it came to $72,053 reduction. We also checked what 15% of the market value of the property was, which was originally $52,228, and that 15% of the market value was to $7,834. The reduction, both of them exceeded the maximum cap that's provided by the resolution approved by the council. So this recommendation is to approve at the cap at $5,000 reduction on the final lien amount.
Yeah, I got first. If we're ready.
Question?
Yeah, first off, on the application, it says that they are actually in any litigation with the city and all that. Right now, it says yes, that they have other legal activity going with the city. Is that right or wrong?
What,
Number 9.
number 9? Number 9?
If they don't qualify.
I don't see a number 9 here. I've got 1 and 2.
On the
First page.
Thank you.
The first page. I don't know, we checked our records and there was no litigation with the city.
So they filled out the application wrong.
They may have, so.
And then right above it, 2 lines up, it says they have 2 different outstanding debts to the city.
Yeah, there are two different code enforcement.
2 cases?
Yeah, so the code enforcement lien numbers are on the top, or
Okay.
the case numbers.
Yeah.
But those totals didn't match it, maybe they just had it wrong. It just didn't match the total for the city lien, that's why it threw me off a little bit.
Yeah, because
Yeah,
it's
you're right about
47,950,
And
I
and it's
had to-
48,350.
So I had to correct, so they were given this before I had the affidavit of compliance. So once I got the affidavit of compliance, I corrected the lien amount, which you see on here. But I didn't have the compliance when they had filled out this application. So this was what my staff took from my liens list.
Yep.
But no, after that, I got the compliance, did the calculation, and that's what you see on here, which is the 48,350.
This is the one, when you were gone, these are the ones I have a problem with. These are all investment companies and stuff like that, where they've inherited these properties and they know they've got liens on them a lot, and they're just abusing the system here.
Oh, yeah, I mean, it's sunsetting soon, I hear.
Yes. So, again,
Yeah, but Tom Baroni handled this case originally, and this property has been out of compliance since 2013, essentially. So maybe there's some value that you can add to the
There's a few
discussion.
things I think you should know, that in 2013, Ms. Carroll did pass away at the hospital. She drove herself to the hospital, passed away there. She has no family, living family, so the property went into an estate for her, and it just sat there vacant for 4 years. So the violations that were there weren't affecting the neighborhood. They were really like stained walls, minor things, but accumulated a fine of $48,000. So it wasn't an unclean pool, stuff like that. It wasn't like that. So just maybe making this decision tonight may make it a little bit easier on you, coming to a conclusion of $5,000. So all I can tell you about the new owner, as soon as he purchased the property, he was in there in a few days, painted the whole place, looks brand new. I don't know what he did inside, but I can tell you from the outside, it looks good. So I just wanted to add that to the board.
Do you know if there's another litigation on that property, like with the city? You have no idea, we don't have clarification on that.
I don't know that.
We have no litigation on that property.
So they've got the application wrong?
Yes.
Okay,
Are we going to amend the application, city attorney?
because technically it doesn't
Fix-
qualify.
It's possible that they misunderstood and they may have thought that the pending lien, but we can confirm, Joe's already confirmed. What we can do is, at the city attorney's office, is also confirm, and if, the only thing I'm worried about is they're willing to pay the $5,000 now, right? This would be put off for another month. But we can, if you want to move this application to the next agenda, that's possibly within your purview.
Does it have to be
But
put off for a month?
you'd have to make a motion on it.
I'm saying, does it have to be put off for a month?
Wait a minute, we were told earlier that our decision is just simply, did it comply with the application or not?
Yeah.
That's all we vote on. We don't make motions to bring it back for another 30 days or nothing like that. That's not what we do.
Well, if you have a concern about whether or not the application is complete or not, and it seems to me that there's an open question of fact, we can move this to the next agenda, and where you'd make that decision, but that's, the only issue before you now is the application complete and have all the criteria been met? And the city's assessment of the application and the criteria is on page 2. And you can see that the city has determined, code compliance has determined that all of the factors have been met.
There are, what we have in front of us, it's not technically correct.
Well, I understand your concern, and we can what Joe has already provided testimony that he has looked into that issue, and that there is no litigation pending. And it could be that this is just either a Scrivener's error, or they misunderstood what litigation meant. But if there is a concern about that, and if it's a material one, we can move this, we can look into that and move this further. You have the city's position on page 2 of the application.
I got one other question for Tom. Tom, do you know when they bought it?
Just recently, it wasn't that long ago, so maybe 3 weeks ago?
Oh, okay. Because I saw on here that it had the old sales record, so I figured it had to be within a month or something like that.
Yeah.
Okay.
Okay, you're right. This is the kind of case that I would see, based on Mr. Baroni's testimony, and we, that it got completed, it got brought up to speed. We have made motions for compliance to be within 7 days. Is it out of the realm of possibility that we say that if this is corrected in the next 3 or 4 days, that the city proceed with the amnesty? If it's not, it comes back to us next month?
Wait a minute. This case, if they just bought this property 3 weeks ago, this case doesn't even comply for amnesty. It had to be out of compliance with the previous owner for so many months. That's the way this program was set up. New owners can't just come in and get amnesty within 3 weeks. That's not the way this was meant to be. This is, it should have been a previous case. A lot of the time period is 6 months or whatever it was before. If they just purchased it 3 weeks ago, this doesn't even qualify.
If you want to, I'm going to withdraw it, and I'll bring it back next month. And then
It
we
still
can,
won't
then we
comply.
can have that discussion.
Sounds good to me.
I'm easy. if you believe that the program requirements do not meet the criteria, and I think you need to vote that way.
Okay.
In my opinion, the reason it's before you tonight is because it met the criteria, and we believe
If they
that
just
they should
purchased the
be
property 3 weeks
recommendations.
ago, it does not meet the requirements,
Then I think
according
you
to
need to
the
vote in that
requirements we
direction.
received.
I'm going to resend out the resolution tomorrow so that you can review it, because I think it's being interpreted wrong currently, but I'm gonna resend it tomorrow, if that's helpful.
What I want to do is, whatever please the board, we will do. But I do not want to take the property owner's right to put this application in and have it reviewed appropriately. So if it needs to be moved, I'll bring it back to you guys with better, with some clarification if you need.
Joe,
Alternatively, we can take a recess, and I can pull the resolution, we can circulate copies, and then I can do 10 minutes of legal research and find out if there's any pending litigation.
Well, the litigation's not the only problem, it's whether it actually qualified.
Right, and
new
that's why
homeownership
I don't have the resolution in front of me at this moment either,
Yeah.
and you can read the resolution and make a decision based upon that.
Joe,
Yes, sir.
the city's gone through all this paperwork that's presented to us here. It's gone through the council before it comes to us. Is that correct?
The council created the program, and there was a resolution that was adopted and approved by the council on what the rules were. We take those rules, and then we review each of the applications to make sure that they meet the criteria. Now, if there was a criteria that required minimum property ownerships, it would be on that list. Now, if we missed it, that means we missed it on all of them. Because if not, there would be a check mark that said yes or no.
Right.
So, but like, you know, I can do what Mr. Garding would like. We can bring the resolution and take a look at it now, and
Yeah, if there's an open question of fact, we can resolve it tonight. I mean, I know the AC is off, but
Yeah.
And
that's great.
I have some of the, I have requirements pulled up in front of me also.
okay, my suggestion would just be to take at least a 5-minute recess, and then Kristen can print out copies for everyone.
And then we'll also double check the litigation if that was an error.
Yes.
Make a motion that we have a recess. I'll say, do you think 5 minutes is enough, guys, on the board, or we want 10? 10. I make a motion, 10-minute recess.
How about a motion until 8 o'clock?
Yes. 8 o'clock.
We'll reconvene at 8.
8 o'clock.
I'll make a
it is.
motion that we recess until 8 PM, and at that time, we'll resume.
First bullet.
Gives us an opportunity to review the resolution, and the city attorney verifies there's the litigation.
So be it.
Sorry, guys, I don't want to come back.
No.
I mean, I didn't realize that it was an investing company. You know, like you said, if it was the family of the Carrolls. If this was the kids, you know, the woman, you know, they've come in, they've cleaned it up, they're trying to sell it, help it settle the estate. Yeah. Yeah. Where's the checks and balances? That's what my.
access, you might want to turn your mics off.
Yeah, I got
Because I have it turned down, but a little still gets through, so.
That parking lot over there on the, south.
I gave it to, Public Works to clean it up.
I'm gonna go along outside, maybe it's cooler out there after the rain.
Joe, you said your address was the same.
Stretch my legs, clear my head.
Take care of it.
Sal, you're not gonna stay? I just came back, I'm gonna be animated, you're gonna miss the show, man.
I'm staying since you're here.
Oh, you're talking about the University Phase One?
Yeah.
The cement guy?
Yeah.
Yeah, I thought you were talking about the other, there's an unnamed street area,
Yeah,
on
there
Phase
is.
Three on the south side.
Yeah, that's where all the TVs were in the street.
Right, yes. I took pictures of that, with the vegetation growing crazy, and we used to go there periodically and clean it up. I can't get it going. So why did you get so agitated? That was from the, I was on the whole.
I don't think he, I don't think it is some of the oddball things you remember, like, you know, what you should do for the city.
I don't know. Good
But
question.
people should still do that stuff.
Good question, but I don't know.
That's the house there, it's, Warren Parkway. Ridgedale, just right down by the lawyer. The old city hall, right there in the middle. Oh, that's City Hall? Yeah, that was, where the casino is. Oh, that's right, yeah. Well, it belongs to the college, yeah. The other one was the real estate office, and then became a church, and I was there in 1964. Yeah.
I haven't spent a night in the house since Thursday last week. Really? Yeah, I volunteered to run McDonald's.
Oh, really?
Yeah,
Oh, I
one of the
didn't know
weekend
that.
managers.
Oh,
So I have
nice.
10 of those, and then I had to work my regular job every day, and I had to work Monday night with Roger. I work in Montgomery HR, finance, so I deal with budgeting, acquisitions, contracts. Yeah. I'm the one that tells them, no, they can't pay somebody something. Yeah, I've been doing it since 2009. Because part of the salary for the road manager, the house across the street, she's the one that makes it for
Yeah, we're ready, but I understand that there's a discrepancy with what was provided to the board and what may be posted on the website, is that correct?
Just some clarification is all that's needed because it's kind of an if and or. I'm looking at here, yes, to answer your question.
Okay.
And if you'd like, I can expound on that.
Sure.
Okay.
And we can also print what's on the website.
Yeah, that's fine.
too.
It says
But I-
eligibility
yeah,
requirements and information. First bullet says code enforcement lien must have been filed for more than 1 year prior to April 1st, 2017, period. Subject property must be titled in the name of the applicant, which I believe this is. But then when I look at the resolution, Section 1, subsection B, the application shall be executed by the owner of the property upon which the lien has been recorded, who will swear an oath as the actually of the information in the application.
Okay, I think I
lien-
understand. So you're not saying that there's a different version of the resolution posted?
No, I'm saying there's
Okay.
interpretation, yeah, no.
All right, you were giving me a bit of a
No.
heart attack.
As I'm
No, I
reading
know.
this, I'm going,
Yep. So I understand the issue I think the way they're consistent, the way the resolution reads, is that the current property owner, to me, the current property owner, the owner of the property upon which the lien exists, meaning the current owner, has to, upon what the lien that's been recorded, has to fill out the application and swear the oath. Right, that's consistent with what's posted on the website,
okay,
right? The owner of the subject property,
yes.
right. So this is a long-winded way of saying the same thing.
It says that when it was recorded,
Right,
that's the issue. When the lien was actually recorded, that name is supposed to be the one that matches that title. Otherwise, the problem you have here is, no quitclaim deeds these houses every other day, you get them dropped down $5,000. That's the precedent.
Well, but the program is temporary, right? And,
I understand that.
right, but that's not the way that it does not say when the lien was recorded. It says, the application shall be executed by the owners of the property upon which the lien has been recorded.
Which, I guarantee you, that lien was recorded on the previous owner, not on the current.
Of course, right, but it's not making the language of the resolution is not making a distinguishment. It's not distinguishing who currently owned it's not requiring that the current, I mean,
subsection.
Joanne Carroll is deceased.
Yes.
You know.
Subsection, right.
Right, but the resolution does not require that the same person, it just says the owner of the subject property upon which the lien was recorded has to fill out the application.
Subsection, yeah, subsection C, the lien must have been recorded in public records at least 1 year prior to the commencement date of the program. If the lien is to be recorded by the owner of the property, this person has not owned the property for a year.
They don't apply.
No,
The subsection C, the lien must have been recorded in public records at least 1 year prior to the commencement date of the program.
right, so
Subset before that, as we're reading this resolution, says that the owner of the property in which the lien has been recorded. So as I'm reading that,
Okay.
doesn't it not build on top of each other?
No, so the lien, all that C is saying is the lien itself must have been, you can't have had a new lien, like you're not gonna qualify for the amnesty program if your lien was just recorded less than a year ago. This has to be an old lien, and that's all C is saying. These liens were recorded in 2013 and 2014. So the lien must have been recorded in the public records at least 1 year prior to the commencement of the date. That's,
But not by the owner.
It's a
Yeah, but
previous
I
owner.
think we
Doesn't-
keep trying to connect owner and lien.
right, there's no
And
connection.
there's no
B
connection.
comes before C.
But when I'm reading B, I see what he's saying. I mean, it says lien has been recorded. It doesn't distinguish whether it's with the owner, the existing owner, or the old owner.
You,
I
it's
get what you're
the,
saying.
Vote on it.
the owner of the property upon which the lien was
We ain't lawyers,
recorded.
just vote
Yeah.
on it.
Well, hopefully had our attorney look at it.
We don't have one.
Yeah, you've been gone.
Yeah, 'cause
We haven't got there yet.
Incidentally, we did, I mean, I noticed in the resolution that the litigation is not a requirement, right? The application needs to be completed. But for the boards, if it provides any comfort, we did do some legal research, and there's no pending litigation with respect to this property.
So the application was just filled out wrong.
It was incorrect. And so Joe, I mean, what I just did is reconfirm Joe's prior research.
So basically, the lien went with the property, has nothing to do with the owner, so whoever owns the property at the time of the
Which it
form
wasn't
was
done
filled
right.
out.
So long as the lien was
Liable,
recorded.
recorded 1 year ahead of
right.
House should have never sold without that lien transferring, without everybody knowing it transferred. That's the problem. This program doesn't, in a typical lien reduction process, that lien would have transferred. The problem is with this program, it doesn't follow those same chains. But it's over.
Yeah.
And,
Thank you for your work. I'd just
No
like to
problem.
Thank them for taking the time during
I never read.
our, thank you.
You're welcome.
I make a motion that the Code Enforcement Amnesty Program application for the subject property 5202 Blaine Drive, Tampa, be accepted.
I'll second that. All in favor?
Aye.
Opposed?
Nay.
Okay. Yes, I do also want to thank you guys for all of this effort tonight, and the rest of you we did have some clarity, I hope. Some clarity, I hope. All right. Any other new business? I have,
He's got it.
I have one.
Mr. Chairman and the rest of the board, I think that would be appropriate for us, since Sal Scarosa, our long-term code compliance officer, is retiring, that we recognize him in some fashion or another. We can make it National Sal Scarosa Night here at the Temple Terrace Chamber of Code Enforcement meeting.
So, stand up or come up to the thing, and give us a
Yeah,
few words.
thank you for your service.
Thank
Yes.
Certainly didn't prepare anything, but it's been a pleasure working with each and every one of you. Some actually a lot longer than others, but it's been a joy. It was a nice run for us. We had a chance today to have some lunch and celebrate a little bit, and I appreciate everything you guys do and volunteering for this. Thank you for your service, but I think it's time for me to move on and play some golf. But
Good for you, Sal.
So golf
Well,
it
thank
is.
you, and it's been a pleasure with.
Thank
Thank you,
Thank you.
Sal.
Thank you very much.
Any other business before us? There being none, do I have a
I'll
motion?
make a motion to adjourn.
All in favor?
Aye.
The minute,